We have a fantastic presentation today that we've been looking forward to for quite some time. I'm Daniel O'Neill. I'm one of the co-chairs of the HYLA CLE committee this year. So the presentation that we're here for is exciting because it covers both kind of the social justice aspect and, in the carrot and the stick way, businesses that have not done the right thing for social justice reasons. There is the stick of now that there's actually a business case for, doing the right thing as far as human trafficking goes. So we're beyond fortunate to have the two speakers we have here today. You all have been with HYLA for a while. Ben Ritz. He and I served as co-chairs of the HYLA CLE committee the prior bar year. Ben is the smartest lawyer I worked with in any capacity. So feel free to ask him very difficult questions throughout this entire presentation. So Ben is a senior attorney with Thompson Co. He studies the court system, so you don't need to. So he is a great resource for difficult questions, anything regarding federal litigation. He's in the insurance coverage division over at Thompson Co. We also have Christina Culver, who is a partner in the insurance coverage department over at Thompson Co. So we're looking forward to this presentation. Thank you again for presenting, and I'll go ahead and turn it over to you all if you're ready to start.
Absolutely. Yeah, I'll get the screen share going in just half a second. So we are going to talk about insurance, human trafficking in the business context. And let me get the share going so you guys can see our sort of PowerPoint presentation, but not quite. Let's see, this one right here. Should work. Okay. Daniel, are you seeing the presentation? Yes. Okay.
Oops, I accidentally muted. Yeah, yes, it's coming through.
Okay. All right. All right. So just to set up the framework, we'll be talking about here is we're not, I'll be doing kind of the initial setup of the federal and state issues, and Christina will be covering the insurance policy coverage issues. So just as obviously, let's talk about kind of the framework of, what are we talking about here? Well, first, you've got a map right here from Palantir, who's done some research kind of showing the hot spots of human trafficking. It's a very big problem. It's a billion-dollar industry. And the next question, of course, is who are we talking about in terms of who's being trafficked? What we don't really know, as you can see, a lot of the numbers are unknown by their very nature. But typically, a lot of these people do get involved as minors. A lot of these people tend to be women, and a lot of these people tend to be foreign nationals who are tricked or lured in here through, promises of false marriage and other things where they don't have as much resources. In terms of what they're used for here in the terms of sex trafficking is escort services, illicit massage, pornography. We're going to focus more on the escort side that tends to happen in the hotel scenario because that's an easy fact scenario to work with, and that's what a lot of the cases have focused on recently in lawsuits. So other than the hospitality industry, we've also got tech, truck stop, and security. And then there are a couple different causes of action you might worry about. Negligence, usually in the form of premises liability. There are federal and state sex trafficking statutes. The federal one came out first, and we'll talk about that one in just a second. And of course, RICO and international conspiracy cases, which ones you'll see in a given case. There might be negligent hiring and supervision, other various causes of action. So before getting into the framework, we thought it might be useful to think of a possible scenario to kind of work through the problem of the statutes with, because it's always good to make things factually specific. So let us move into, we're going to mostly focus on Texas because most of you are probably Texas practitioners, although, we do have some research on the Louisiana area and some other areas as well. So let's move into Texas. So moving into the hospitality industry, let's say about, a year ago, there was an incident where one of your client's businesses, who owns a chain of hotels, had a raid happen because there was some sex trafficking going on. They said they didn't know. But it happened. They got it. They cleaned up the place. Things have been going fine for about a year. And then you get a panic call one afternoon because guess what? The trafficking victims are now suing them. And they're like, can they do that? How does that work? what are my responsibilities? Can my insurance help me out with this, either in the defense or the payment of the actual claim? In this instance, they tell you, and you don't have to remember all this because we'll go back to it, that the traffickers, they rented rooms. You found out, your client confesses that he found out that the janitor was acting as a lookout for the traffickers. They tended to pay in cash and have long stays where they didn't bring any luggage, and the people who came to visit the rooms didn't bring any luggage. But no one ever really saw the victims. No one ever saw anyone that looked disheveled. There just didn't seem to be too much other indica in their mind as to what was going on, as they didn't know. And they typically don't have a lot of crime like that in the area. Like most of the crime that, when they were checking the charts to see if other hotels or in the area had it, most of the other hotels and neighboring places within, about a mile radius, typically had reports of theft. Somebody jumped out of a car one time. They're, mostly petty theft issues, but nothing really approaching the level of kidnapping. So that's our scenario. So let's move into the federal cases. So back in about 2000, Congress decided to extend the pre-existing criminal liability around the criminal liability issues to civil and give a civil cause of action for the trafficking victims, both for damages and for attorney's fees. 2003, they updated it. And this is the rather lengthy language, which you can see, whoever knowingly benefits financially by receiving anything of value from participation in a venture, which that a person knew or should have known has engaged in an act or violation of this chapter. Well, that's kind of wordy, so let's elementalize it. So there are kind of three elements. Oh, got a typo, I'll fix that later. Sorry, that was invisible. The three type of elements are knowing benefits, participation in venture, and knew and should have known. Courts will reorganize those a little bit differently. But typically it'll be benefit and venture and knowledge, or benefit, knowledge, and then venture. So what does that mean? Well, in terms of the federal side for the crime element, it typically is a broad range of recruiting, enticing, harboring, transporting, advertising, maintaining, pretty much very, very broad, as most criminal statutes are. When the civil one is a little bit more specific, and there's a divide as to whether or not you need to include the criminal liability in determining whether or not there's civil liability. If you are, and they did there was a judicial panel where they had a multi-district survey for one of those bigger cases. And on the Southern District of Ohio and Western District of Washington took the view that the civil liability, which is 1595, is distinct from the criminal liability. States such as Georgia and New York, and I think now Florida, take the opposite view. And we're going to go through each of those cases. Right now, we're looking at what I blurred out as a Wyndham Hotel, because there is a case called MA versus Wyndham Hotels over in Columbus, Ohio. There were some signs of trafficking happening, such as, again, the trafficker paid in cash. They tended to rent rooms near the exits for long periods of stays. There was lots of condoms and other drug paraphernalia. Also, they did see the victims, and the victims would often show bruising and would not make eye contact in the hallways. One of them even ran out to the hallways, and their cries for help were ignored by staff. And one online review even indicated that prostitution and drug use was taking place at the hotel. So the court, there was a motion to dismiss filed, and the court had to rule on the motion to dismiss. And that's where most of these cases come from, are motion to dismiss cases. And they looked at each of these three elements. The benefit is usually pretty simple. Did they rent a room? Now, you do have to do more than renting a room, but that's where we get into the other two elements. The venture and the joint venture and knowledge elements typically turn on the facts in the case, which are some of which I just already mentioned. In the case of the knowledge, they went with knew or should have known as to knowledge. And on the one end of the spectrum, they considered one case, which is Rico versus McLean, where the victim watched the hotel owner high-five each other when they brought in yet another victim, versus at the other end, you have Lawson v. Rubin, where the victim allegedly only had one visit by the police, and there's like one maybe ambulance in the past 6 years. There's really no signs whatsoever that any trafficking was taking place. So looking as between those two extremes and the facts that I just mentioned, such as cries for help being ignored, the drug paraphernalia, the long stays near exits, the cash and so forth, the court found that they may not have known, but there was at least signs that should have alerted the staff that something was going on, so that the knowledge element was met. So the next question came to participation of venture, and this is where you have the split between the two lines of authority as to whether or not to use the criminal statute to inform the civil statute. The reason for that is because there isn't a definition of participating in a venture in the civil statute. There is one in the criminal statute. The trouble is that the criminal statute doesn't use should have known, it just used knowingly. So, and the criminal statute uses knowingly assisting, supporting, or facilitating. This particular court at the Wyndham case felt that if they use the criminal status, then the should have known language would be rendered meaningless, and that would interfere with Congress's intent. So as a result, they did not adopt the definition from the criminal statute. They kept with the should have known, and basically on the same facts as discussed for the knowledge element, they found that there was participation in a venture, meaning that the hotel was involved in the venture of sex trafficking because they're renting rooms to them, they're looking the other way, et cetera, et cetera. So to look on the other side, we have a different Red Roof Inn case. Now, there's a little star there, it says Red Roof Inn there. I blocked it out just in case, you know, people have issues later. This one took the opposite viewpoint. Yeah, we don't want Red Roof coming after us. But that is, I tried to take pictures from the hotels where I could that were actually involved in these cases. So there are 4 different individuals who sued this particular one for sex trafficking. We're not going to get into the facts of it, probably due to time, but suffice it to say, on the venture element, they went the other way, which is to say that they took the definition, they kind of removed the should have known and went to knowledge of assisting, supporting, or facilitating. And because they went the other way, they granted the motion to dismiss. They didn't find it supporting that finding. Now, I will clarify that that was as to particular defendants. The case is still ongoing. That particular decision, that motion to dismiss, is on appeal. And there were other defendants who tried to get out a motion to dismiss and that were more directly involved. And they have not been, those motion dismisses were denied. So it may depend upon kind of how close you are to the actual incident in question. So that's the framework for the federal side, benefit, venture, and knowledge. So let's go into Texas law. So Texas, as a species of negligence, typically considers these claims under premises liability. And there's 2 kind of lines of cases. The majority of them focus on, they all focus on foreseeability, and they either focus on whether there were similar incidents or whether there was immediately preceding conduct that would indicate something was going to happen. The similar incidents is the more common test, but it's not held to any less regard. It's just the most likely one to be employed. Now, as you know, there's generally no duty to protect someone from criminal acts by a third party, but a property owner controller does have that duty of ordinary care to invitees to protect them from the criminal, and that's what we're dealing with in the hospitality industry. So then we come around and see, is this the right kind of thing? Is this enough to put them on notice that they should have done something to protect the people involved? So these is a Timberwalk Apartments. We didn't have a hotel case, but there's a well-regarded Timberwalk case, and there are basically 5 different factors the court will look at. I mean, it breaks down to kind of common sense, but this is how the court tends to elementalize these things. You can see them right there. Proximity is whether the criminal activity happened close to or near the property. How recently, taking them out of order, how recently the criminal conduct occurred, how often the crime occurred, how similar the previous crime was to the alleged crime, what publicity was given to the instances when the landlord knew about them, such as publishing that review earlier. So in this particular case, a tenant sued an apartment owner for negligently failing to prevent the sexual assault. In that particular case, there have been no, violent crimes in the complex for the preceding 10 years. So that goes to similarity, recency, and frequency, depending on how you break it down. Only one sexual assault had occurred within about a 1 mile radius in the previous year. And the 6 assault type crimes in the neighborhood complexes were not really publicized or known, although they did occur in police reports. So the Supreme Court of Texas ruled that that was not foreseeable. Now, the Supreme Court of Texas also later clarified in another case called Trammell Crowe v. Gutierrez that it is important that the crime be similar. They discussed a bit more on how similar the crime needs to be. So that particular case involved a murder, and they compared it, what kind of things need to be similar enough to a murder for it to count as the right kind of crime. And they had some assault, some weapon possession, and related, and some vandalism and theft. They'd had basically 10 other crimes in what was a marketplace, and the property manager did know about them. As to recency and frequency, the court noted the market had a relatively low rate statistically of crime and violence. This was in San Antonio, and in general, the residents, the area, the ratio was like 44,760 to 1 in average. And an expert calculated within the past 2 years prior to this gentleman's death, the odds of being attacked as he was as a murderer in this particular circumstance was about 1.6 million to 1. So very unlikely. The robberies that occurred were not violent robberies. They were just, asking for cash, or almost never a weapon or an attack was involved. And this particular one was pretty much an intentional, deliberate hit on that particular guy. So the court held that the other crimes were not similar enough to have put the manager on notice on his duty. On the other end to find one that didn't find it, we have judge alarm via Comfort Inn, and in that one they had someone jumping on the roof of a car, theft of property from hotel, and theft of money from register. That one also didn't find the Timberwalks. That one. So you have some different ones going different ways. Now, as far as the alternative to the Timberwalk factors, the one that's immediately present or immediately foreseeable, that one's pretty easy to illustrate. That one involved a bar fight. So in that particular case, that's still Lago Partners versus Bradley Smith. A bar patron was suing the owner for injuries from a bar brawl. The court found the nature and the character of the premises, which is a bar, can make criminal activity, namely a drunken bar fight, much more foreseeable. And given the nature of what happened at that particular case in terms of what was going on, in terms of rowdiness and so forth, there were repeated aggressive contacts between patrons about 90 minutes before the fight, et cetera, et cetera. That would be enough to allow the owner to anticipate the criminal conduct. That's probably not going to apply as often in the sexual trafficking issues, because they tend to be more ongoing and tend to be less immediate. So those are the general factors as far as premises liability and federal liability. I'll mention that most other states tend to have some sort of similar rubric in that they do look at prior occurrence of crimes, location, and nature, and whether they knew about it. That's certainly what Louisiana does. And we will move on to more directly coverage, because of course you've been sued, there's been a pleading, they made certain allegations in that pleading, and so now your client, after you've gone through the statutes, try to take a guess, and we'll go at the end whether or not it applies, whether or not they might be individually liable. They're also worried about whether or not they can make a claim for coverage, either for defense or for indemnity on their insurance policy. So I take it away to Christy.
Yeah, no, thanks, Ben. That's a really good introduction to the causes of action that we're seeing against our insureds in these premises cases, which is the basis for the sex trafficking allegations. Just to back up, Daniel, I'm really glad you brought up the social justice aspect. From an insurer standpoint, this is something that we do not want to pay for. We do not believe we should have to pay for it. It's not the risk that we took on when we sold a policy to one of our insureds. And there are going to be some cases coming out in the legal media, I think, in the near future with respect to the Communications Decency Act. They're trying to get the law changed against the tech companies. So we are going to be seeing more of these sex trafficking cases on Law 360 and some other legal news sites that come out. So be on the lookout for that. It's super interesting. I'm a nerd. I have to say that because I believe it. But to back up on the coverage issues, as Ben said, the main insureds we see in these cases are hotels. So anywhere from a nice Hilton to a not so nice Red Roof Inn in Georgia. And the CGL policy, just to back up further for those of you who just, it's a brief overview. Those are the policies that you see the deck page in your slip and fall cases and your CD cases. They pay for accidents, for negligent acts of the insured that would cause a third person's bodily injury or property damage. There's two sections, and that's broken out on the slide, coverage A and coverage B. As an insurance nerd, I'm really excited to talk about coverage B because we do not see that very often. So coverage A is going to be your typical bodily injury, a broken arm. Here, the sex trafficking are the sexual injuries. Coverage A also does provide for property damage. We really don't see that in the sex trafficking cases, but as an example, that's what you're going to see in your construction defect cases is property damage. For coverage B, what that provides coverage for is personal and advertising injury. Here, that's going to be your false imprisonment allegation. The victims are alleging in their petitions that they've been falsely imprisoned in the hotels or truck stops by their traffickers. And so that's where coverage B comes into play. And as a coverage nerd, we get excited that we get to see that. Not excited in this context of because it's sex trafficking, but that we get to deal with it because otherwise we would see it usually in a defamation or a slander case, which are not that common in the CGL context. So as Ben said, there's two issues here. One, you want to have your insurance company pay for your defense costs. That means your attorney's fees and your court costs. Two, if there's a judgment entered against you or there's going to be an ultimate settlement, you want your insurance company to pay for that. That is the indemnity side of it. That's when I usually say these claims are covered, is usually because the insurance company may or may not pay for any judgment or settlement against your client. Duty to defend is what we're seeing right now. We're seeing a lot of the pleadings from some very skilled plaintiffs' attorneys getting their petitions passed, a 12B6 motion. So courts are finding, because of the way these cases are pled, that most carriers do have a duty to defend. And that is because for certain reasons, and that's where the exclusions are going to come in. So for coverage A and coverage B, coverage A has the expected or intended exclusion. So they're going to say, we're not going to pay for any bodily injury that is expected or intended from the insured standpoint. So if the plaintiff can show what they're going to try to show in their sex trafficking case is that the hotel knew about the victim being trafficked, they knew about her injuries, and then what the carrier can do on that side is use that evidence to show that, well, then the insured inspected or intended those injuries, and there's no coverage under coverage A of the policy. Coverage B has the criminal acts exclusion. And it pretty much says we're not going to pay for any injuries, which would be the false imprisonment injuries from arising out of a criminal act. So evidence for both of those can be taken from the underlying case, and a carrier can say, we're not going to pay for any of this, you need to pay for it yourself. So that's where courts are usually finding that there is a duty to defend. Ben did a really great job of breaking down the federal statutes. The state statutes pretty much follow the federal statute, and plaintiffs' attorneys are doing a very, very good job of pleading their cases into coverage with respect to a duty to defend. And in that instance, you'll get a letter from your carrier with probably a pretty long list of exclusions, and they're going to reserve rights and say, at the end of the day, we're not going to pay for this. So that gets into some of the exclusions that we're seeing in the policies, and a lot of the exclusions are very similar in many cases. The first is going to be the assault and battery exclusion. This one applies to coverage A and coverage B. And so when I get a sex trafficking case in, the first thing I ask is there an assault and battery exclusion in the policy? If they say no, I say, well, that's a different story. You may have to take this case up. If there is, it's pretty much a denial on the duty to defend and the duty to indemnify. That is because the assault and battery exclusion applies to bodily injuries arising out of assault and battery. That includes negligent hiring and supervising, lack of adequate security on the premises. And so why that's important is because a lot of times the negligent supervision, negligent hiring, and lack of adequate security allegations in a petition can get around the criminal acts exclusion and the expected or intended injury exclusion. So what the assault and battery exclusion does, it's an endorsement on the policy, and it pretty much just says we're not going to pay for any of those allegations or an ultimate settlement or judgment arising if those allegations are true, and the exclusion applies. So that's the biggest one we're seeing, where an insurer can come in and say, we're going to deny the duty to defend, we're going to ultimately deny the duty to indemnify, and you need to go hire your own attorney, we're not going to pay for anything. With respect to survival of a motion to dismiss, if you have a really good broad assault and battery exclusion, most courts are upholding them nationwide. So we're seeing pretty much consistent rulings from courts that if you do have an assault and battery exclusion in your policy, that you do not have the duty to defend, regardless of whether they're alleging, RICO, a violation of the federal statute, violation of the state statute, and just straight up negligence and premises liability. So that is the insurer's strongest defense at this point in the litigation nationwide, is the assault and battery exclusion. The next one, which is a little bit trickier, is the abuse and molestation exclusion. When the insurance industry drafted these, and I'm going to probably may not use some PC terms, they were looking towards the more traditional abuse. These really came about when you saw the clergy, the allegations against the clergy. So what's interesting about the abuse or molestation exclusion from a coverage standpoint is how they are worded. A lot of them may say we're not going to cover any bodily injuries caused by anyone if the injured person was in your care, custody, and control. The problem with that is if I'm representing the hotel, I'm going to say, well, the guest is not in my care, custody, or control, so the exclusion doesn't apply. Courts who've looked at that specific language have said that care, custody, control means, guarding, watching, keeping. So if the hotel says, I had no idea that the victim was even on our premises, it's not a scienter element, but is almost an awareness and knowledge element. If the hotel can prove that, then I would say, and courts have said that the abuse and molestation exclusion does not apply. But you also have some exclusions in the policy for abuse and molestation that are much broader, that generally just say we do not pay for any bodily injury caused by abuse and molestation by anyone on your premises. It's a pretty broad exclusion. If that's in there, then you have an opportunity to, as a carrier, to say, okay, we have no duty to defend or we have no duty to indemnify you because of that broad language. So it just depends on the language in the policy and what the court's going to do with that. I did want to mention, and it's not in the, oh, we do, okay, I'm glad you put this up there, Ben. There's also the sexual abuse exclusion. I don't see those as often as I see the abuse and molestation exclusion. But again, the sexual abuse exclusion is just, we do not pay for any bodily injuries arising out of sexual abuse. If I do see them, they're pretty broad. The language is pretty broad and courts do uphold them. The communicable disease one is a strong one as well. I see those more in property policies. They're less rare in CGL context, but if they are on there, it's most likely for a large hotel chain. And it's that they're just not going to pay for any bodily injuries arising out of a communicable disease. So it's pretty much just like we call it the STD exclusion. So you'll see those a lot in cases as well. I did want to mention the Communications Decency Act. I brought up that social justice issue. I'm sure most of y'all have seen that Facebook argued before the Texas Supreme Court earlier this month. I know the plaintiff's counsel on that side, Amy McAdams, I have a panel with her on some of these issues later this week. And she's basically trying to get the law changed, because what the CDA does now is says like Facebook, Instagram, Twitter, They're not responsible for, it's like a publisher's defense. They're not responsible for the third parties publishing content. But what Justice Thomas did in a recent case last year, where the Supreme Court denied cert, has issued a statement that said that may need to change down the road. And he specifically pointed out the case against Backpage, and has laid the groundwork for the sex trafficking victims to go up before the United States Supreme Court and get the CDA changed with respect to the social media aspect of that. And Justice Thomas pointed out that it's because the sex trafficking victims' allegations are design allegations. It's a design flaw in their social media platform that is allowing the traffickers to come on and exploit them and sell them for sex. So it's different than just a publisher's defense. I think that's something to look for. It's going to potentially change some of the coverage issues down the road if it happens. Annie also told me that they are going to hit the hospitality industry a little bit harder this year. She's already sent out 700 notice letters to certain premises. What they're doing nationwide is separating the allegations against the tech companies from the hospitality industry. So I think you're going to be seeing a lot more lawsuits filed against the hospitality industry this year and in 2022, if that's next year. So that's my spiel. Any questions?
Well, before we get there, just to
Oh, sorry, Ben.
No worries. Just to review, give the framework for everyone. So this is just a real quick brief overview of what we covered before we jump into questions. So we've got the Trafficking Victims Protective Act, which of course focuses on whether they received a benefit, participated in a venture with them to some degree, and knowledge, meaning either knew or should have known, depending upon where you are. Premises liability, which regardless of state is going to focus on foreseeability. And then of course the different, whether or not the insurance covers it at all, namely bodily injury or in the small cases property. And then of course the different inclusions that we just talked about. It just using the hypothetical that we used, for example, the person who called you and late afternoon panicking, going back through the facts that I mentioned at the beginning, yes, they rented a room, which was a knowing benefit. Two, as to both venture and knowledge, in that particular scenario I threw out, there was a janitor who was a lookout. There were long stays where they're paid in cash. There was no luggage. But we didn't see any victims. We didn't see drug paraphernalia, we did that. So it's, more of a closer call than some of the other cases that have gone one way or the other. So there might be some room to argue there. In terms of premises liability, it was more like one of the cases that I mentioned, which didn't have any similar crimes in the area, and that kind of will knock out some of the foreseeability. So in that particular hypothetical that would be proposed, there might be some liability under the Protection Act, but there may be less likely liability under the premises liability. And then of course, depending upon, and this is important, how it's pleaded, how the plaintiff pleads, whether or not these exceptions are going to trigger. Like if they plead it smartly, if they just, then, if they don't plead something that sounds like the assault and battery, then they might be able to get past that exception. If they plead something more about exploitation, it might run afoul of getting them the Trafficking Act, but it might get past the insurance claim. So that's kind of a balancing act that the smart plaintiff attorney can need to do. And, it is something that might be considered in the sense that, oftentimes the people who commit the criminal acts other than the hotels are fairly judgment proof. So, that's in terms of actually getting the money. So
I think that's a good distinction. And also, but that's a good distinction, Ben. And I've talked with some of the victims' attorneys, and some of them don't even want insurance to pay for it. They're just trying to make a statement, as Daniel said, social justice. They want to bring awareness to the hospitality industry and this problem, and they want the actual insured to pay, not the insurance company. So some of them actually plead out of coverage for that purpose.
Yeah, and that was just, I wanted to go back to the overview real quick, but yeah, questions. We left time for questions if people have them. And I can leave this up or take it down because I can't see questions right now. Do we have any questions, Daniel? Are they coming in?
No questions yet, but
okay.
This would be a good break. I'm going to put the MCLE number in the chat. If anybody has trouble with that, just send me a message. everybody should be able to see that now.
Yep, I see it. And I guess while we're waiting on questions, I didn't mention them, but the penal code reference for Texas is Chapter 5, Section 20A, and the Civil Practice of Remedy Code for Trafficking of Persons is Title 4, Chapter 98. My presentation, of course, focused more on the federal, but when you look at them, you'll see they're similar in approach. And same thing with Louisiana and other states. They're constantly coming out with new ones because, as Christy mentioned, there have been in the past year or so a lot of suits filed against hotels and similar long stay places.
Yeah, I think the next one we're going to see are the security companies.
We can't just start calling on people from the participant list.
As you like.
But that was a fantastic presentation. Thank you both so much for presenting. We can still give it another minute or two if you'd like, just to kind of see if anybody's typing a long question right now.
Sure. I guess while we're waiting, but Christy, why don't can you explain more on your theory on the security companies being hit next?
Yeah, I think it's going to be, it's kind of goes to the conspiracy allegations that we're seeing. A lot of times you have the traffickers who have people, well, I guess the traffickers actually will get employed by a security company for a hotel, and so they're the lookout. Use the example that was the janitor. A lot of times now we're seeing a security cop on the premises is actually conspiring with the trafficker to get the victim in and to keep the police away. We've seen some cases where hotel employees are actually part of it, and they will give the traffickers notice if someone's called the cops. A lot of the petitions that are filed have Yelp reviews. I mean, you brought that up to where prior customers have complained about drug use, prostitution, trafficking. And so that's a big issue. And when we see that on the defense side, we're seeing them gathering evidence that the actual hotel employees and security guards were part of the trafficking, I don't want to say process. So it goes to the conspiracy allegations that we're seeing in the petitions and the RICO allegations. So I think they're going to start hitting some of those security companies individually as well.
That makes sense. Interrupt with questions anytime.
When just real quick, that's really interesting that Yelp reviews could feature into that in some way. That's really cool to leverage technology like that.
Well, even Green Sheet would work. Like I said, the Supreme Court of Texas, one of the factors they look at is publicity, and the idea is twofold. One is reviews on that particular property that's showing evidence that they knew or should have known because someone's leaving reviews in some way, shape, or fashion. But it's also used in publicity within a certain radius of that particular property. How much is that owner aware that similar crimes are occurring at other places that aren't their business? Because that could also put them on notice as they should have known or should have looked into the issue. That's the publicity factor of Timberwalk and related.
Thank you, Samuel. We have our first question. Samuel asked, do you see the same statutes being used against owners of short-term rental or Airbnb properties?
I personally have not seen any claims against Airbnb or short-term rentals, but from a coverage aspect, I would imagine they would be required to have a CGL policy, and obviously would have a property policy that would include the assault and battery and the disease exclusions. And so I think some of the same coverage issues would apply there, but I personally have not seen any cases against them yet. But that's a good question.
And certainly, when I was doing my research, I did not see anything brought in the Airbnb context or similar short-term stay properties.
is the industry is kind of adapted to, you know, not just the social justice stuff, but that there's a legitimate business case for the, you know, the more and more lawsuits, as you were saying, you know, the 700, you know, kind of letters that are going out this year. Is there, are there any chains that are maybe starting to rebrand their advertising, you know, like stay at our hotel, you won't see any human trafficking? You know, has anybody tried that yet? Or is that's something that just nobody's seen yet?
I haven't seen that yet.
Yeah.
Go ahead, Ben.
No, I haven't seen that. What I have seen is because going towards the should have known aspect, is I have seen when I was researching the cases, some hotels will put on evidence of training programs. So there are kind of, I guess, human trafficking sensitivity training programs where they're teaching hotel staff about what to look for to spot trafficking victims, to report them to the police, or otherwise get them out of the situations that they're in. And in addition to the humanitarian reason to do that, the businesses are also trying to, I think, build a case that they're taking proactive steps they can turn around and show the court that said, look, Your Honor, you know, we told all of our, this is more probably for the higher end franchise, you know, owners of, let's say, Wyndham, as opposed to the individual hotel. So the franchisers, like, we're going to require all of our little hotel franchisees to do these trainings so that if one of them turns out to be involved in or in cahoots with the sex traffickers, then Wyndham bigger can say, well, you know, Your Honor, we took the steps we're supposed to do. We told them what to look for. We told them these are things we've learned from these other cases. You know, please list out of this case. We didn't have any reason to know. And these are steps we took proactively to prevent it. So I've seen that. I've seen them take those steps. And I guess while we're waiting, in case anyone else has any question, in Louisiana, I know we didn't get into that. They also have a similar negligence duty risk analysis where they focus on the prior occurrence of similar crimes, location, nature, and condition of the property, and if the management or employees knew that the criminals are about to commit the crime. So they have a slightly different test, but as I said, that's an example of a variance from the Texas one. And one of the reasons that the location, nature, and condition nearby is, I think there was at least one, trying to find it right now. There's one like Hyatt or something that was attached to that, to one of the kind of the malls that you kind of wander in and out of in New Orleans. So there was an issue there as to whether or not, like, a crime that happened like on their doorstep was their responsibility. And it was, because they knew that kind of stuff happened there. But so that's to give you an idea of the feel of a different state, neighboring state. So
I did see recently in a petition out of Florida, which I don't want to offend anybody who jokes about Florida, but to me, if you're going to see this, you would see it there in New York, is they allege negligent rescue, that the hotel employees had a duty to rescue the victim, which is, to me, ridiculous, but it's Florida. So if it would fly anywhere, it'd fly there.
And it did. If I recall correctly, that was sustained, one of the many claims that was sustained against a motion to dismiss. At least at the motion to dismiss phase.
Yeah.
The court was hedging a little bit there. It is a different standard, so that may not survive later on, but the court did say that several times. So, okay. So I guess it looks like we've covered all of human trafficking now and forever. So at least until the case law updates.
Definitely. Well, thanks again so much for presenting. This was an excellent presentation. Thanks for everybody joining us. If you have not already RSVP'd for our next CLE coming up in April, it's a joint event with the HBA, basically highlighting the difference of advocacy in arbitration versus mediation. So it should be a great learning opportunity. Brent Stogner from Abraham Watkins is presenting I think he's the mediation person, but it should be a fascinating one. So I guess if that's it, thanks again for everybody joining us, and hopefully we'll see you next month at the next one.
Thanks, everyone.
Right.
Thanks,
Right.
Daniel.
Have a great rest of the day, and thanks again.
Absolutely.